Hello everyone, and thank you for coming. My name is Suzanne Sayward. I'm an attorney with the law firm of Samuel Sayward Baler. We're located in Dedham, about 25 minutes down Route 1A. And I'm here for a program that's co-sponsored by the Mass Bar Association and the Massachusetts chapter of NALA, which is the National Academy of Elder Law Attorneys, which are attorneys who help people who need estate planning, sometimes Medicaid planning, those types of services. I'm actually currently serving as the president of the Massachusetts chapter of NALA for this year. And the program is put on in the honor of Elder Law Month, which is celebrated in May. And the Mass Bar Association places or sets up these meetings with senior centers around the Commonwealth and asks attorneys to go out and talk a little bit on a topic of concern to elders. As part of the program this year, everybody who attends will get a copy of this publication put out by the Mass Bar, which is really very good. I don't know if anybody's had a chance to look at it, but she didn't let you. Oh, wow.
No, don't touch that. We'll wait till you cover it.
Oh, okay. Well,
we always obey.
It's a little, it gives you a little summary on topics like Medicaid, aid and attendance, veterans benefits, reverse mortgages, and I took a look at it. It's really a very nice summary. So everybody take one of those, and I hope you'll find them helpful. I've also brought some brochures on the elder law attorney. Sometimes people don't really understand what an elder law attorney does and why it's important if you have issues that you consult with an attorney who is well versed in those areas. And I brought some of my firm brochures if anybody is interested in them. A couple of topics. When I sent out the program notice to Norma, as I was reading it over, I realized it was kind of an odd coupling of topics, but I think they're both important and not really well covered in the book, so I want to talk about something that wasn't there. The first topic really has to do with powers of attorney and healthcare proxies. Does everybody here have a power of attorney and a healthcare proxy? Raise your hands if you have them.
I have a healthcare, but
not a power of attorney?
Right.
Well, let me tell you a little bit about what those documents are. Come on in. A durable power of attorney is a document that you use to legally appoint someone who can basically sign your name for you. And the point of it as an estate planning tool is in case you become incapacitated. You're ill, you're in the hospital, you develop an illness, you get hit by the bus. For one reason or another, you're not able to sign your name, talk to the insurance company on the phone, make decisions about your assets, pay your bills, register your car. So the durable power of attorney is the document that you use to appoint somebody to do that for you.
I have a question. I put him on my account. So it's both names are on the bank account?
You mean your child?
Yes.
You know, that can certainly address the issue of having somebody having access to it, but sometimes it's more than just having somebody on the account. So, you know, sometimes you need to deal with the insurance company, or, like I said, register your car, or get your mail, or fight with the credit card people, any of those kinds of things. So a durable power of attorney is important to have. Healthcare proxy, very similar. It says this is the person who is legally authorized to make pull the plug or make any other type of healthcare decision. You know, HIPAA is a federal privacy law that went into effect a couple of years ago, and it's that law that makes you have to sign a form every time you go to the doctor or the chiropractor or the dentist. And really, HIPAA concerns privacy laws, which is good. I mean, we don't want people being able to have access to our medical records without our permission. Unfortunately, like many laws, it can sometimes create unintended results, and one of the results from HIPAA is that you know, you're in the hospital and your daughter from Ohio calls up and says, oh, you know, how's my mom? And they say, we can't talk to you because of HIPAA, bye. You know, so, you know, those kinds of things are an unintended result. But back to the healthcare proxy. The healthcare proxy says this is the person who not only can get information about my condition or talk to my doctor, look at my medical records, get a second opinion, choose my caregivers, and also make decisions regarding end-of-life care or any other course of treatment. So, durable power of attorney, healthcare proxy. Very important to have in place and to do them while you're well and able. And these have always been very important estate plan documents. In fact, I'll often say to clients who come in, power of attorney is your best friend if you ever need it, because without it, if you get sick or have an accident, your family will have to go to the probate court and seek a guardianship for you in order to be able to get access to your assets or information. And that is something that in the past you have always wanted to avoid. I mean, you probably are familiar with probate and wanting to avoid probate, you know, doing your estate plan so you avoid probate. That's probate when you die. Probate while you're alive is even worse. And that's what a guardianship is all about. You're in probate, it takes a long time, it costs a lot of money. That is about to get worse. As of July 1st in Massachusetts, new guardianship laws go into effect, which, you know, were intended and are intended to protect older people, vulnerable people, people who are being preyed upon. You know, someone who's alone in the world and they're being taken advantage of. I don't know if any of you saw, I think it was about 6 months ago, the Boston Globe did an expose on guardianships, and they sort of recounted several cases where there was either an inappropriate placement in a nursing home or somebody who was not really being well looked after by their guardian. And there's no doubt about it. Those abuses can happen and do happen, and it was good to get protection in place. But you know what? From my point of view, when I usually see when I do guardianships, what I usually see is parents have, for one reason or another, not planned. They don't have a durable power of attorney or a healthcare proxy, and now well-meaning good children, we're not talking about evil children, we're talking about good children who really just want to help their parents. You know, they're trying to help them take care of things, and so they don't have that legal document. The parent is incapacitated, so we have to go to the probate court for a guardianship. Under the new law, this is going to become so burdensome and so expensive. The petitioner, that's the good child, is going to have a lawyer. Now the parent is going to be required to have a lawyer. The court then is going to appoint a guardian ad litem, which is generally a lawyer. And you know, don't get me wrong, I love lawyers, I'm a lawyer. But you know, lawyers are expensive. And so this is going to make the process really even more expensive. So the best thing you can do to protect your assets, your family, is do a durable power of attorney where you get to choose the person who would be helping you if you needed it. Similarly, healthcare proxy. So just wanted to bring that up. Any questions, by the way, on that? Healthcare proxies, durable powers of attorney? Everybody over 18 should have one. I mean, there's really no reason not to.
Does the power of attorney take effect after you're dead?
Good question. The question was, does the power of attorney take effect after you're dead? And in fact, no, it's just the opposite. The power of attorney is in effect only while you're alive. The authority of the person named under the power of attorney ceases when you die. At that point, it would be your executor under your will, or if you have a trust, your trustee, but your power of attorney no longer has any effect once you pass away.
What is the process for getting a power of attorney?
It's not hard.
Is it like the healthcare proxy?
Yeah, it's a little bit more, there's generally a little bit more to it than that. Healthcare proxies, you know, if I have clients that come in and do estate planning, I will do a healthcare proxy for them. But I have lots of clients who get the forms either off the internet or, you know, from their doctor, and that works fine. Power of attorney, you want to have a really well-drafted, comprehensive power of attorney, because there have been some cases, in particular in the tax arena, that have held that if your durable power of attorney does not specifically authorize a particular action, then the person you've named can't do that. And there are many, many things that you might think, oh, well, that will never apply to me. That down the road, it becomes important to say, oh, do you have a gifting power in there? Do you have specifically power to deal with national service life insurance? Do you have a specific power to register a car or sign a title, deal with real estate? So I would recommend that you go to your estate plan lawyer to have your durable power of attorney done rather than just pick up a form. That's a better way of doing that. By the way, also the term durable, which I've been using, a lot of times the question is, well, what's a durable power of attorney versus just a non-durable power of attorney? A durable power of attorney is a statutory document, meaning we have a law in Massachusetts that says that if you write a durable power of attorney and you say in it that the document will not be affected by your subsequent disability, it means that the document will not be affected by your subsequent disability, i.e., I do my durable power of attorney while I'm well, I have an accident and now I'm incapacitated, my durable power of attorney is effective to allow my appointed agent to act for me. If I don't have that magic language in there, then if I become incapacitated, my power of attorney is no longer good. So, obviously a non-durable power of attorney is not appropriate for this type of planning. When would it be appropriate? Say I have a piece of property that I'm in the process of selling, but I have to leave the country, so I want somebody to do that for me. But I want it to be limited and specific, and I only want it to happen if I'm still alive and well. So I give this limited, specific, non-durable power of attorney to, my friend or my child to do this for me. But for the most part, in the estate planning arena, you're talking about using a durable power of attorney. Okay, so the other thing I wanted to talk about, which also is touched on very briefly in the book, is a program under the Medicaid system, which is Mass Health here in Massachusetts, which is called the Home and Community-Based Waiver Program. And this is a community mass health program that will provide some services to individuals who would otherwise have to be in a nursing home because of their condition. The reason I want to bring this up is because I think a lot of people don't realize that there are programs out there to provide some services at home, and that even if you're not dirt poor, you can still be eligible for these programs. In particular, this program works really well for a husband and wife where one person of the couple would otherwise have to be in a nursing home. Generally, in order to be eligible for any community-based programs, you can't have any assets and you have to have pretty low income. Under this program, say the husband is not well, but with some support could stay at home. Well, they could qualify for these benefits. All the assets could be put in wife's name, not a problem. And as long as the husband's income is under $2,022 a month, then he could be eligible to have services that would allow him to stay at home. What kind of services? Home health aid, shopping, meals, skilled nursing care, a personal care attendant, so that one, spouse doesn't have to bear the burden of doing all of those things, which can be very, can cause the spouse to really suffer some real health issues. And also to provide those services so that spouse doesn't have to be in the nursing home. And the great thing about this program is you don't even need a lawyer to access it. Typically, this type of services are best accessed through what's called the ASAPs, the Aging Services Access Point. You guys may have had people from your local ASAPs come and talk here, no?
I'm not aware of it.
Okay, for Norfolk, I think it's...
I'm an employee of HESCO Elder
HESCO,
Services.
yeah.
Yeah,
HESCO.
yeah.
Sharon.
Okay, so they're for Norfolk, and I wanted to, anybody here from Franklin? Okay, that was close to, that's Tri-Valley. But anyway, so, they will typically come out and do an assessment. They will fill out the forms for you and help you process that. But, I've got a couple of clients who are have qualified for services under the home and community-based waiver, and it's really great. In one in particular, the husband is relatively young. He's 65, which is the cutoff point. for the program, but the wife still works, and she goes to work every day. And he'd been in a nursing home for a year, and he was able to come home, and it's not 24-hour care, and, so you still need to be aware of that. But with this support, he was able to come home and stay at home, which is really what people want. Mm-hmm. So I just wanted to talk a little bit about that. Okay, and then I wanted to give everybody an opportunity to ask questions. Sometimes people have questions about other topics. I would be happy to answer them for you if I can, or, yeah?
On this program you were just talking about, you said the husband could sign over his assets to his wife, or vice versa, I suppose. How does this apply to IRAs?
Oh, well, that's a good point. Okay, let me repeat the question. The question was, I said under the Home and Community-Based Waiver Program, the ill spouse could transfer his assets to the well spouse. First of all, the reason I said that is because in order to be eligible for the program, the individual applying can't have more than $2,000 of countable assets. So, when you're talking Medicaid, Mass Health, your countable assets are really just about everything you have, with a couple of exceptions, the most notable being your home, car, burial contract, etc. But, if you've got other assets, you could still qualify for the program by transferring them to your spouse. So the gentleman's question was, what about an IRA? An IRA is a problem because if you can transfer it to your spouse, but it's a taxable event. So, this just goes to point out everybody's situation is really unique, so you would need to see whether or not that's going to work for you. Now, depending upon the amount of the IRA, it may make sense to liquidate it, pay the taxes, and move the money over. Say it was $40,000. That may not result in that much of a tax, especially if you have offsetting medical deductions. But if you're talking about somebody who has a $500,000 IRA, it's not going to be a good idea to liquidate that to move it over to the spouse because you'll get killed in the taxes.
What about guardianship within a spousal arrangement?
The question is on a guardianship with a spousal arrangement. Well, if if you're married and you have a situation where your spouse is incapacitated and you find that you're not able to either get access to an asset or make certain decisions, and you don't have a durable power of attorney, then yes, you will still have to seek a legal guardianship for your spouse. As nonsensical as that seems, you would have to do that. So that you can
act within that, one or the other can act to take care of all the financial services of the family.
Right, so that you can act for the finances. Now, if you have a durable power of attorney that, appoints your spouse.
You have to do a double then, or if you only have one person who is ever capable of doing that, the other one will have to do that whole thing. And can you have then, say, a child of one of your children also handle the same situation?
So the question is, on a durable power of attorney, is it a good idea between spouses to have a reciprocal document? And if one of the spouses is not able to take on that responsibility, is it a good idea to name somebody else or to have what's called attorney in fact? And the answer is yes, you certainly would want to do that. So if you have one spouse who, if say it's the wife who takes care of all the financial stuff and knows where everything is, and the husband has no interest or knowledge of it, and then in that situation, the wife would certainly want to name somebody else under the power of attorney. What I often do in those circumstances is name both the spouse and a child. For psychological reasons, I think that usually feels better. But, and you would also then want to have a backup. So, you name your spouse and then you have a backup, which can be one or more of the children. There's, a lot of people have different thoughts about whether or not you should name two or more people to act together. I think in many circumstances, having what's called co-attorneys in fact. So I say I name my spouse. If my spouse can't do it, I name my children and they can act together or alone. That can work really well, provided the two people that you name can work well together and are reasonable people. And the reason it can work well together is what I always tell my clients is remember, if somebody has to step up and start acting under the power of attorney and basically run your life, that's a really big job. I mean, I have enough trouble running my own life, never mind trying to run somebody else's at the same time. So if you have two people, they can help each other. You know, all right, you deal with this, I'll deal with that. And it can work out well. Now, if they're going to be at odds, or if there's going to be a power struggle, then you're just going to make it harder for them. So, you know your own family. I don't. So you need to really think about how well that would work.
Can you say also then that, say I'm the spouse that's in charge and the other spouse is incapacitated, can I say also that the child cannot act before me or will have to act after me if I'm incapacitated?
Yeah. So the question is, when you set up your durable power of attorney and you say, I name my spouse and then the children or child as an alternate, yes, the alternates typically would not kick in until the primary is unable to act. And what I usually say in my power of attorney is the person dies, becomes incapacitated, and it's important to set a standard for how is incapacity determined or resigns. Any other questions?
What do you think about reverse mortgages?
Oh, so question on reverse mortgages. Well, the thing that people don't like about reverse mortgages, that nobody likes about reverse mortgages, is that they're expensive up front. Anywhere from cheap is $8,000 up to $13,000 or $15,000. So, that's a lot of money. On the other hand, they can work very well in certain circumstances. Those circumstances, for example, are, I have clients who really want to stay in their home, they love their home, they have really limited assets other than their home, their income they're getting by okay on, but they can't afford to paint the house and fix the roof and pave the driveway. So a reverse mortgage in that case can allow them to take care of that maintenance and keep the value in the home. So it can work really well in that circumstance. It can also work really well. Somebody really wants to stay at home. Say they need some help at home, like a home health aide, and it's going to cost them some money every month, money that they don't otherwise have. So a reverse mortgage can feed, will pay a certain amount each month. So you can either get a lump sum, or you can say, I'm going to get $800 a month, to help make ends meet. And so, my philosophy is always look after yourself. And, if you have assets left over to leave to your children, that's great. But you've spent your lives raising your children, sending them to college, getting them to the point where they should be, self-supporting. It's not your duty to leave them an inheritance, especially at the expense of yourself. If I hate to see clients who do without because they're worried that they won't have enough to leave to their children. I just don't like that.
I told my children they won't have to fight. I'm going to spend it all.
There you go. That's the way to. That's perfect.
There you go.
So, yeah.
I'd just like to ask a question about, I'm not sure if I'm saying this right, a life estate.
Yeah.
Can you give me some information about that?
Sure. Question was, what's a life estate all about? Life estate typically refers to a situation where I deed my home to my children, but I retain the right to use and occupy it during my lifetime. So why do I do that? Typically it's done because I'm worried that at some point in the future I'm going to have to go into a nursing home, and I don't want my house to be subject to a Medicaid lien for reimbursement for amounts paid on my behalf for my nursing home care costs. It can be a very good planning strategy. It is popular here in Massachusetts, and it does work to preserve the property. A couple of very important things to know about it. You're probably familiar with the 5-year look-back period. That means that if you give away assets and then you need to apply for Medicaid to pay for your long-term nursing home care within that 5-year period, you're going to be ineligible for Medicaid because of that transfer, because you gave that away. And giving your house away, even though you keep a life estate, would be considered a disqualifying transfer. So you need to be aware of that 5-year rule. The other thing you need to be aware of is that even though you keep the right to reside in your property, you don't own your house anymore. So if you decide after a few years, geez, wouldn't it be great to sell the house and go to assisted living or move to Florida or buy a condo, it's not yours to decide to sell anymore. Now, your children could join into a sale with you, and I'm sure that all of your children are wonderful and would be quite willing to do that, but the issues come up is sometimes they can't. Like, your kid is in the middle of a divorce. Your child gets sued and now has liens or creditors looking for him. Your child has a tax lien. Your child's run up credit card bills. Your child becomes disabled and now is receiving governmental benefits himself. Your child dies. So there are all sorts of things that might interfere with your child's ability to do that. The other thing you need to know is that you're probably familiar that with the capital gain tax rule that says anybody, you don't have to be over 55 anymore, if you sell your home and you've owned and occupied it for 2 out of the 5 years prior to the sale, you can exclude up to $250,000 of capital gain on the sale. And that's per person. So if you're a married couple, that's $500,000 of gain you can exclude. But if you give your house to your children, you keep a life estate, well, your children own an interest in your home as well. And it's not their primary residence. So if the house then gets sold, their interest is going to be subject to capital gain. So there could be tax due if the house gets sold. And the house gets sold and their owner, remember, the money goes to them. And of course, I know they would all give it all back, if they were able to. But, then you run into gift tax issues. So it's not as simple as it sounds. And I'm not saying that nobody should do it. I have lots of clients that do it, and it really can work very well. But you need to make a very thoughtful decision, and you need to understand, okay, here are the consequences, here are the advantages. Here's what you want to think about to see whether this works for you.
I think they said something about having to that your children, you can get rid of some of your assets by, I think it's up to $11,000 a child over a certain period of time.
It's like I planted her in the audience to sort of feed me these questions.
No, I've read that somewhere.
So let me talk about that for a little bit. So the question had to do with being able to give away, $11,000 a year. Now that goes to the issue of the gift tax. The gift tax is part of the estate and gift tax system, which is a federal system. We don't have a gift tax in Massachusetts. So the gift tax was put in place to prevent this situation. So say, right now everybody can pass on federally $3.5 million free of any estate tax. That's as of this year. But say I'm extremely rich and I have $5 million and I'm on my deathbed and I know that my estate's going to get whacked with a big tax when I die. So I write a check for $2 million to my children or to that gentleman over there, and then I give it away, and then I die, and then I only have an estate of $3 million, so there's no tax, right? Wrong. They figured that one out. So this is where the annual gift tax exclusion comes in, and actually as of this year the amount is $13,000 per person. So you can give $13,000 to as many people as you want. You're not limited to children or grandchildren or friends. And that will not have any effect on your estate or gift tax.
It's $13,000 total, or
no, $13,000 per person.
Yeah.
So if I have 5 children, actually let's make it 10. If I have 10 children, I could give $130,000 in 1 year. And each calendar year, I could do that. Now, if I give more than $13,000 to any one person in any one calendar year, then I have made an excess gift. So say I give my child $113,000 in 1 year, and then I die. I no longer have $3.5 million to pass on free of estate tax, because I used $100,000 of my credit when I made that $113,000 gift. I made an excess gift of $100,000. So that comes off my freebie when I die. But there is no freebie for Medicaid planning, for nursing home, long-term care planning. The Mass Health does not allow you to give anything away free within that 5-year period. They have gone so far as to challenge or tell people that they were ineligible when they wrote $25 checks for their grandchild's confirmation gift. They said ineligible transfer. So they are wicked. So, you know, you just need to be aware of that. There is an exception that says that they're not to consider as disqualifying transfers that were made that were not intended to make the giver eligible for Medicaid. But time after time, when you try to invoke that rule, you're just they just shoot you down. They just don't they don't care about that. So there's no freebie for Medicaid.
What about putting your house in trust?
Okay, so the question is, what about putting your house in trust? There's two different types of trust, two different basic types of trust. There's lots of types of trust, but basically you can have a revocable trust or an irrevocable trust. A revocable trust is just like you. So you can put assets into it, you can take them out again. Your trust is you, as I like to say to my clients. That type of trust is typically used for two purposes. One, you want to have your assets avoid probate. You don't want your kids to have to go to the probate court and deal with probate after you die. The other reason you use a revocable trust is because you want to control the distribution of your assets. So say you have a child who's disabled and you want to make sure that his or her share is protected in what's called a supplemental needs trust or a special needs trust. You would use a trust to do that. Or you want to benefit young grandchildren, but you only want it to be used for their education. So a revocable trust is very common, used for estate planning purposes there. A revocable trust does not help you in any way with respect to keeping your assets away from having to be spent down for your care or making you eligible for Medicaid. It's considered a fully countable asset if it's in a trust. An irrevocable trust, it's just what it sounds like, you know, it's irrevocable. Once you create it, you can't change the terms of it, and once you put assets into it, you can't get them back again. That's the type of trust that is often used for long-term care planning, to put assets into a trust. Again, you've got to be really mindful of the 5-year rule to take them out of your countable estate in the event that you need long-term care in the future. And a lot of times people will, rather than just do a deed with a life estate, they will transfer their home to an irrevocable trust for Medicaid planning, because it gives you a lot more flexibility than just giving the house to the children. You know, you can protect it against their creditors. You can change your mind, so you always can hold that over their heads. Or if I don't like what you're doing, I can, you know, change how my house is going to be distributed. You can preserve the tax benefit. So it gives you a lot more, it's a lot more flexible. Of course, it costs a lot more money to do. So, you know, it's a price.
One other
Do a
question.
life estate that isn't 100%, and you just keep a small percent of it?
I'm not sure I understand what you
Well,
mean.
I'm trying to explain it. I had heard that you could keep as little as 1%, and therefore you would still have a vote if they wanted to sell it. You
Well,
could say no.
Yeah, and the same thing with the life estate. I mean, the beauty of a life estate is that, you know, it prevents your children or whoever you've given the house to from selling it out from underneath you.
Right,
You know, you
right.
won't be a front page
That's
Boston
what I
Herald
meant.
story kind of thing.
That's what I'm trying to say.
Yeah, so you retain that either by way of a life estate, it will do the same thing, or a 1% interest.
Okay.
You could do that. I'm not sure there's any advantage. Well, it would depend on your circumstances. For the most part, you might be better off with a life estate, because you get the exclusive use of the property.
All right.
Yeah.
Do they have to pay taxes on that, capital gain tax, the person in the life estate who gets the home?
Well, if you do a deed with a life estate and, I transfer it to my children.
You're transferring the deed, right?
Yeah, so I do a deed, I sue, give my house to my children, I keep the right to live in it. That's not a taxable event. So, nothing has been sold, no money has been exchanged hands, so there's no taxes there.
Until it's sold, right?
Until it's sold.
Okay.
Now, the other great thing about doing a life estate is that if we keep the house until I die, then the house gets what's called a stepped-up basis. And that means that when my children sell the house after I'm gone, the value for tax purposes, the basis, is the value, fair market value at the time of my death. And this is opposed to if I gave my house outright to my children. So say, for example, I bought my house for $50,000, maybe I put money in to improve the roof and done some capital improvements, but say the basis is $70,000 and my house is worth $300,000. If I just gave it outright to my children, I did not keep a life estate, then they take it at my basis. My $70,000 basis is their $70,000 basis. So when the house gets sold, whenever they sell it, they are going to pay capital gain tax on the difference between that $70,000 and the $300,000 that they sell it for. If instead I keep the life estate, I give them the property subject to my right to use it, they keep it until I die. When I die, that house is fully includable in my taxable estate, which might sound like a bad thing, but remember, for federal estate tax purposes, I've got a $3.5 million coupon. That can go tax-free. And Massachusetts, it's $1 million. You can pass on $1 million free of estate tax. So if really all I have is my $300,000 house, then having it fully includable in my estate is a very good thing, because it means that the basis for tax purposes is the $300,000. So when my family turns around and sells it for $300,000, no tax needs to be paid.
I was going to ask the question about, I'm sorry.
No, that's all right. I just wanted to know, does that type of estate go to probate?
No, if you do a deed, if you convey your property before you die and you keep a life estate, there's no probate, because the kids already own it, so they don't need to change the title.
Does that count in their assets then?
You mean like for financial aid purposes?
Yes.
That's a good question. I've been told no, it doesn't.
Or for getting a loan, for that matter.
For getting a loan, it would probably help them. But I'm not sure how much a lender would care about that. But it's a vested interest. They own whatever percentage is of that house. So, it is an asset. Now, it's subject to mom and dad's right to live there till they die. So, the bank couldn't foreclose on it and sell the asset. Well, I guess they could, but who wants to buy a 1/3 interest in a property subject to my right to live there until I die? It's not really worth that much. But I sometimes get the question of, will it affect parents who are applying for financial aid? And I've been told no.
So it probably doesn't count as an asset either.
Yeah, I'm not sure.
If your children get into trouble financially, can they put a lien on it?
Yes, they can. So that's another thing too. That's another of the downsides. Yeah, that's right. The question is, if your kids get in trouble, and they own your house, even though you have a life estate, can their creditors put a lien against it? And they can. And I've had that happen to clients, and it's very troubling.
Yeah.
The creditors, again, they can't sell the house out from underneath you, but it's disconcerting.
How does homestead figure into all this? Homesteading.
Okay, that's a good question. A homestead is just a piece of paper that you can file with the Registry of Deeds. That it's a possessory protection, really. The government in its wisdom thinks it's a bad idea that people be thrown out on the street. So the homestead will prevent your creditor from forcing a sale of the property to satisfy a debt. But it doesn't make the creditor go away. They can stand there until you die or sell the house, and then they can collect their money. It also has nothing to do with a nursing home or Medicaid or protecting the property in any way for that purpose. So it doesn't help you there.
What use is it then?
Oh, well, say you're like a lawyer and somebody might sue you, then, having a homestead on your house is a good idea. Or you're a nurse or a doctor or an excavator. You have your own business, you got in a car accident. So any of those kinds of liabilities is what it's good for.
just want to ask a question about joint ownership of the home between a husband and a wife. And can that be changed, since it originally was purchased under that, in that way? Can it be changed to a, what they call tenant in common, where they can, one or the other can sell it after one or the other passes away without having to pay any kind of a probate charge or any of that?
Well, there's three types of tenancy for real estate. Typically between spouses, if you look at your deed, it probably says something like, Jack and Jill, husband and wife, as tenants by the entirety. And tenants by the entirety is just a special form of joint ownership between spouses that not only says when one spouse dies, the house belongs entirely and automatically to the survivor. That's what joint ownership is. But it also gives a little bit of creditor protection. So if one spouse has a little business and there's some creditors of the business, the tenancy by the entirety would prevent those creditors of the business from being able to force a sale of the home to satisfy that. Joint tenancy can be between anybody, and it's typically referred to as joint tenancy with rights of survivorship, meaning that when one joint owner dies, the property belongs entirely and automatically to the survivors. No probate, it just happens automatically. A tenancy in common is when you own separate interests. So a husband and wife could own property as tenants in common, but and for estate tax planning purposes, there might be reasons why you would do that. But when one spouse dies, if you own as a tenant in common, this other spouse will have to probate that interest. It won't pass automatically.
Oh.
And a tenancy by the entirety cannot be broken unilaterally. What does that mean? It means that if you decide you don't want to be a joint tenant with your spouse, but you own it as tenants by the entirety, you can't deed your interest over, like, to you and your kid in order to separate yourself and make it a tenants in common. You could do that with a joint tenancy, but you can't do it with a tenancy by the entirety. Okay, anybody else? Well, listen, don't forget I'll hang around for a little bit if you have questions, but please come get your books. Now they're up for grabs.
I have a question.